Good morning. Welcome to our live webinar with myself, Advocate Mohammed Abduroaf. Today's topic, minor child surname change. I often receive requests for advice on the issue of the change of a minor child's surname. To put you into the loop, let's say the mother and the father, they were in a relationship and a child came there from, but they never got married. They agreed that the child has the surname of the father despite not getting married, and they registered the surname as such for the minor child. Years go by, the parties are no longer together. The mother, she remarries or she marries someone, or she continues with her life elsewhere. The reality of the matter is the minor child has the father's surname, but not the mother's surname. And there are certain challenges. The obvious one would be when the minor child attends school or enrolls for something, or when someone compares the mother's surname to the child's surname, they see a difference. The mother's surname is A, but the child's surname is B. And there's always these two surnames in that specific household. The mother would always have to explain, and sometimes the child does not understand why do I have a different surname as the mother. And what sometimes happens, or at least when it comes to my office, the father was not very much involved in the child's life. The child does not know the father, but the child has the father's surname. So that's one scenario. The other possible scenario is the mother, she remarried, she married someone else, and now she has a new surname, a different surname. She may have had the father's surname before, and the child has the father's surname as well. But she would like now to change the minor child's surname to her new surname. But these are the dynamics that are applicable, something which I deal with quite often. And many times it happens when these type of consultations do take place, they take place in the presence of the new partner or the new person in the mother's life. So in dealing with these specific questions, we have to look at the law. Let me get to it quickly. I'm scrolling through the Births and Death Registration Act just to give you some type of overview on how it looks. So at the top, Births and Deaths Registration Act 51 of 1992. When a child gets born, you have to register the child, obtain a birth certificate, and so on. If the child's child or someone passes away, of course, you have to register that as well. And name and surname, etc. It all gets dealt with in terms of the specific piece of legislation. You can see here registration of deaths, past some other relevant part of this piece of legislation, alteration of forenames, alteration of surnames of a minor child. Okay, so that's where we will stop for the specific purpose of the specific webinar. If you have any questions, feel free to pose it on the Advocate Mohammed Abduroaf Trust Account Advocate Facebook page, and I would be happy to answer any questions that are posed. Section 25, Alteration of Surname of Minor. I'll read it out for us all to be on the same page and explain as we go along. When the birth of any minor child out of wedlock has been registered, and the mother of that child marries any person other than the natural father of the child. So let us put ourselves into that specific frame of mind. Child was born out of wedlock. The mother and the biological father of the child were not married, or were never married. The mother now intends to marry someone else. That's in the one scenario. Scenario B, the father of any minor child is deceased, or his or her parents' marriage has been dissolved, and his or her mother remarries, or his or her mother, as a widow or divorcee, resumes a surname which she bore at any prior time, and the father, where the marriage has been dissolved, consents thereto in writing, unless a competent court grants exemption from such consent. So another scenario where the minor child and the mother would have a different surname because the mother now assumes a different surname and so on. C. The birth of any minor child out of wedlock has been registered under the surname of his or her natural father, and the natural father consents thereto in writing, unless a competent court grants exception from such consent. So we are picking up the theme that where a child has a natural father's surname, his consent is required if the mother wants to change the surname to a different surname, either her old surname, her current surname, or the surname which she assumed with her new husband. Let's go further. And D would be, or a minor is in the care of a guardian. Then we go further. The bottom part of the paragraph says the following: his or her mother or his or her guardian, as the case may be, may apply to the Director General for the alteration of his or her surname to the surname of his or her mother, or the surname which his or her mother has resumed, or the surname of his or her guardian, as the case may be, and the Director General may alter the registration of birth of that minor accordingly in the prescribed manner, provided that the man who married the mother of the minor mentioned in paragraph A or B shall grant written consent to the alteration. Okay, so what are we saying there? Now the mother wants to change the surname to that of the new husband, the minor child's surname to that of her new husband. Under those circumstances, she can do that. It is possible. You apply to the Director General, but you require the consent of the biological father and you require the consent of the new husband because now the minor child will be taking his surname. And obviously, it makes logical sense because people may presume that he is a biological child, sorry, the biological father of the minor child. Then here's an 1A of the specific act. It says the following: notwithstanding subsection 1B and C, the natural father's consent is not required where the mother has sole guardian of the child concerned. That's a very interesting part of this piece of legislation. So if a minor child was born and the father was not involved at all in the minor child's life, the father abandoned the minor child, and the mother continued with her life without the father being at all involved in the child's life. He didn't pay maintenance, he didn't exercise contact with the minor child. Under those circumstances, and he was not married to the mother, of course. Under those circumstances, he would not have acquired any parental rights responsibilities, at least that of guardianship over the minor child. And then the mother does not require the consent of that specific biological father to change the minor's surname either to her previous surname, her maiden surname, or the surname of her new husband, which she has now obviously assumed. The long and the short of this matter, or this topic, is if you are the guardian of the minor child, your consent is required for the change of the minor child's surname to a different surname. Let's look at it from a different perspective or a different angle. Let's say you are now the biological father, and the minor child now has the surname of the biological mother. You are not married to the biological mother, but circumstances have made it expedient or a good idea, or at least in your mind, a good idea for the minor child to have your surname. Then, at the same principles applicable, you would have to apply to the Director General for consent to change the minor child's surname, or he or the Director General would have to apply his or her mind to it and change the minor child's surname to your surname as a father, but the mother needs to consent to that because all biological mothers have guardianship rights over a minor child. If, however, the mother does not consent to the change of the minor child's surname to your surname as the father, you would have to approach the competent court. And the court, ultimately, if you are successful, if you can prove to the court that it would be in the minor child's best interest, the court would say, Dad, you are allowed to apply to the Director General of Home Affairs for the change of the minor child's surname to your surname without the mother's consent. But the court cannot make an order directing the Director General to change the surname. The court can only allow the application to be made without the mother's consent. So there's two different angles at how you should look at this specific scenario. Number one, when you and the mother applies for the change of the minor child's surname, it is still up to the Director General to change the surname. If he or she believes it is in the minor, not necessarily in the minor child's best interest, but if he or she believes that the law allows for it. So that's a normal application. Mother and dad would apply. But if one of the parents does not want to give consent for that specific surname change, all that the High Court can do as upper guardian of minor children can specifically stipulate, Director General, do your job, do whatever you have to do, apply the law, etc. But for the purposes of applying your mind, you do not require the consent of one of the parents. So that is it, the long and short of the specific topic. It's a very interesting topic, something which many people do not understand. But to summarize it, and from my view on how to simplify it for you, I would say if you want to change a minor child's surname to a different surname, if you are the mother, you require the father's consent. If he does not want to give you consent, and he is a co-guardian, of course, then you will have to approach the High Court as upper guardian of all minor children, and that specific court would dispense with the father's consent. And the opposite would apply as well. If the father wants to have the minor child have his surname, and it often happens a lot, where the child gets born, the minor child has a mother's surname by default. Soon thereafter, the father gets very involved in the minor child's life, and sometimes that specific father he takes over the care of the minor child. He becomes a custodian parent of the minor child, for lack of a better way of dealing with it or saying it. He becomes the child's mom, as the mother would have been. And years go by, and there's a problem here because the child has the mother's surname but not the father's surname, and problems obviously arises. Under those circumstances, it might be a good idea for you to approach the court if the other party does not want to agree for the minor child to have your specific surname. So let's be a bit more informative. What do you do? It's easy for me to say, sitting here in my office, you approach the court. But how do you approach the court? Do you visit the court and make an appointment with him and say, I would like to obtain an order? No, that's not how it works. Court proceedings are a bit complicated, a bit different than normal type of applications. It's court, it's litigation. Ultimately, you'll have to file an application, basically a notice of motion, stipulating what exactly you want. So you say you would like for the court to dispense with the requirement of the co-guardian to give consent for the surname change of the minor to the Director General of Home Affairs. So that's generally how what you will stipulate. And attached to that, you would file an affidavit stipulating who you are, who the mother is, who the child is, the history of your relationship, and why you want to change the minor child's surname to your surname. That's very important. What's the basis there for? You will, of course, want to deal with the issue concerning the other parent not consenting or agreeing to that or not cooperating, etc. And why would you say it would be in the minor child's best interest for the child to have your surname, etc.? So that's your affidavit outlined very well. The other parent could be the mother or the father, depending upon the facts, would read what you had to say and file a answering answering affidavit, basically stipulating why he or she disagrees with what you have to say, or putting their version across to the court. And then you'll get an opportunity to file a replying affidavit in response to whatever new things that were mentioned in the answering affidavit, or as they sometimes call it, the opposing affidavit. The matter would be set down before a judge. The judge would have, both sides of the story, and then the judge would ultimately make a decision as to what is in the minor child's best interest. If the judge is of the view that it would be in the minor child's best interest to have the surname of the applicant, the party which came to court, the applicant under these circumstances, let's say the father, then the court would say, yes, Dad, you may approach the Director General of Home Affairs. Take with this order which says that the mother's consent is not required for your application. If the father is unsuccessful, then that will be it. The court will dismiss the application. And things will remain the way it is. The parties, of course, can agree upon later to have the full consent to be given, and they can both approach the Director General of Home Affairs later on and say, you know what, we feel that it would be best for the minor child to have that specific parent's surname, and the Director General would deal with the application as it would in any other application. I hope that gave you some clarity, assisted with the specific issue. I do not see any questions. I see some reactions. Thank you very much for that. And hope to see you online again next time. Have a lovely day.